In this video, we're going to discuss whether you can discharge attorney's fees in your bankruptcy. So stay tuned, bankruptcy bailout buddies. Welcome, debtors and borrowers, to Bankruptcy Bailout, because debt ruins lives, not bankruptcy. My name is Matt Burkus. I'm a Colorado-based bankruptcy and student loan relief attorney. And today's topic is about eliminating attorney's fees in bankruptcy. So let's set a little context here. So you're involved in some sort of legal dispute and you have been ordered to pay your opposing side or the other side's attorney's fees. Now, is that something that you can eliminate in bankruptcy? Well, as with most legal questions, the answer is it depends. But the general rule is this, is that attorney's fees follow the debt. So if the underlying debt or claim that was brought against you can be discharged in bankruptcy, then the associated attorney's fees for bringing that claim may also be discharged in bankruptcy. Now, you don't see this too much in consumer cases except in one scenario, which we'll get to in a second. This is more common in business scenarios. So for example, if you're a business owner with a brick and mortar location, you have a lease and business doesn't go well, you breach the lease and you owe thousands upon $1,000s of rent. The landlord sues you, gets a judgment for you, and because that lease is going to contain a provision that if you have to be sued to collect, that you're going to pay the losers or you're going to pay the landlord's attorney's fees. So attorney's fees become part of the judgment. All right. Well, all that can be discharged in bankruptcy. That's a simple contract claim that's gone, that went to a lawsuit, got a judgment, but the associated claim, the breach lease, and the attorney's fees to try to collect on that breach lease can be discharged. The notable exception, which you will see in most individual bankruptcy cases, is when it comes to family law matters. So if you're involved in a divorce or that involves child custody, child support, spousal support, and you've been ordered to pay your soon-to-be ex-spouse's attorney's fees, then those fees are almost certainly non-dischargeable. Okay, because you can't discharge child support, you can't discharge spousal support, so the attorney's fees associated with that family law case cannot be discharged. But here's a quick little tip that my fellow attorney brothers are not going to like, is you can actually discharge your own family law attorney's fees. All right, so even though you can't discharge your ex-spouse's attorney's fees, you can actually discharge your attorney's fees as the case may be. So just remember, the general rule is that attorney's fees or claims for attorney's fees follow the debt. So if the underlying debt can be discharged, then the attorney's fees associated with collecting that debt may also be discharged. And if the debt cannot be discharged, then the associated attorney's fees won't be discharged. The other scenario where this can sometimes come up is if the debt is related to fraud or embezzlement, because again, that's an exception to discharge. So if you're being sued along the lines for some sort of fraud that you committed or embezzlement, then of course, if you are ordered to pay the opposing attorney's fees with that, they will also be non-dischargeable. Again, my name is Matt Burkus, Colorado bankruptcy and debt relief attorney. My contact information is at the end of this video as well as in the description. I offer free initial phone consultations to the residents of Colorado for bankruptcy, but I help people nationwide with student loans and tax debt. Best of luck to you.